whether colored or white, shall stand equal before the laws of the states. And in regard to the colored race, for whose protection the amendment was primarily designed, that no discrimination shall be made against them by law because of their color. The words of the amendment, it is true, are prohibitory, but they contain a necessary implication of a positive immunity, or right, most valuable to the colored race, the right to exemption from unfriendly legislation against them, distinctively as colored, exemption from legal discriminations, implying inferiority in civil society, lessening the security of their enjoyment of the rights which others enjoy, and discriminations which are steps towards reducing them to the condition of a subject race. That the West Virginia statute respecting juries, the statute that controlled the selection of the grand and petty jury in the case of the plaintiff in error, is such a discrimination ought not to be doubted, nor would it be if the persons excluded by it were white men. If in those states where the colored people constitute a majority of the entire population, a law should be enacted excluding all white men from jury service, thus denying them the privilege of participating equally with the blacks in the administration of justice, we apprehend no one would be heard to claim that it would not be a denial to white men of the equal protection of the laws. Nor, if a law should be passed excluding all naturalized Celtic Irishmen, would there be any doubt of its inconsistency with the spirit of the amendment. The very fact that colored people are singled out and expressly denied by a statute all right to participate in the administration of the law as jurors because of their color, though they are citizens and may be in other respects fully qualified, is practically a brand upon them, affixed by the law, an assertion of their inferiority, and a stimulant to that race prejudice which is an impediment to securing to individuals of the race that equal justice which the law aims to secure to all others. The right to a trial by jury is guaranteed to every citizen of West Virginia by the Constitution of that state, and the constitution of juries is a very essential part of the protection such a mode of trial is intended to secure. The very idea of a jury is a body of men composed of the peers or equals of the person whose rights it is selected or summoned to determine, that is, of his neighbors, fellows, associates, persons having the same legal status in society as that which he holds. Blackstone, in his commentaries, says, "The right of trial by jury, or the country, is a trial by the peers of every Englishman, and is the grand bulwark of his liberties, and is secured to him by the Great Charter. It is also guarded by statutory enactments intended to make impossible what Mr. Bentham called packing juries. It is well known that prejudices often exist against particular classes in the community, which sway the judgment of jurors, and which therefore operate in some cases to deny to persons of those classes the full enjoyment of that protection which others enjoy. Prejudice in a local community is held to be a reason for a change of venue. The framers of the constitutional amendment must have known full well the existence of such prejudice and its likelihood to continue against the manumitted slaves and their race, and that knowledge was doubtless a motive that led to the amendment. By their manumission and citizenship, the colored race became entitled to the equal protection of the laws of the states in which they resided, and the apprehension that through prejudice they might be denied that equal protection, that is, that there might be discrimination against them, was the inducement to bestow upon the national government the power to enforce the provision that no state shall deny to them the equal protection of the laws. Without the apprehended existence of prejudice, that portion of the amendment would have been unnecessary, and it might have been left to the states to extend equality of protection. In view of these considerations, it is hard to see why the statute of West Virginia should not be regarded as discriminating against a colored man when he is put upon trial for an alleged criminal offense against the state. It is not easy to comprehend how it can be said that while every white man is entitled to a trial by a jury selected from persons of his own race or color, or rather, selected without discrimination against his color, and a Negro is not. The latter is equally protected by the law with the former. Is not protection of life and liberty against race or color prejudice a right, a legal right under the constitutional amendment? And how can it be maintained that compelling a colored man to submit to a trial for his life by a jury drawn from a panel from which the state has expressly excluded every man of his race because of color alone, however well qualified in other respects, is not a denial to him of equal legal protection? We do not say that within the limits from which it is not excluded by the amendment, a state may not prescribe the qualifications of its jurors, and in so doing make discriminations. It may confine the selection to males, to freeholders, to citizens, to persons within certain ages, or to persons having educational qualifications. We do not believe the 14th Amendment was ever intended to prohibit this. Looking at its history, it is clear it had no such purpose. Its aim was against discrimination because of race or color. As we have said more than once, its design was to protect an emancipated race and to strike down all possible legal discriminations against those who belonged to it. To quote further, in giving construction to any of these articles, amendments, it is necessary to keep the main purpose steadily in view. It is so clearly a provision for that race and that emergency that a strong race would be necessary for its application to any other. We are not now called upon to affirm or deny that it had other purposes. The 14th Amendment makes no attempt to enumerate the rights it designed to protect. It speaks in general terms, and those are as comprehensive as possible. Its language is prohibitory, but every prohibition implies the existence of rights and immunities, prominent among which is an immunity from inequality of legal protection, either for life, liberty, or property. Any state action that denies this immunity to a colored man is in conflict with the Constitution. Concluding, therefore, that the statute of West Virginia, discriminating in the selection of jurors, as it does, against Negroes because of their color, amounts to a denial of the equal protection of the laws to a colored man when he is put upon trial for an alleged offense against the state. It remains only to be considered whether the power of Congress to enforce the provisions of the 14th Amendment by appropriate legislation is sufficient to justify the enactment of Section 641 of the revised statutes. A right or an immunity, whether created by the Constitution or only guaranteed by it, even without any express delegation of power, may be protected by Congress. So in United States v. Reese, it was said by the Chief Justice of this court, rights and immunities created by or dependent upon the Constitution of the United States can be protected by Congress. The form and manner of the protection may be such as Congress, in the legitimate exercise of its legislative discretion, shall provide. These may be varied to meet the necessities of the particular right to be protected, but there is express authority to protect the rights and immunities referred to in the 14th Amendment and to enforce observance of them by appropriate congressional legislation. And one very efficient and appropriate mode of extending such protection and securing to a party the enjoyment of the right or immunity is a law providing for the removal of his case from a state court, in which the right is denied by the state law, into a federal court, where it will be upheld. This is an ordinary mode of protecting rights and immunities conferred by the federal Constitution and laws. Section 641 is such a provision. It enacts that when any civil suit or criminal prosecution is commenced in any state court for any cause whatsoever against any person who is denied or cannot enforce in the judicial tribunals of the state or in the part of the state where such prosecution is pending, any right secured to him by any law providing for the equal civil rights of citizens of the United States or of all persons within the jurisdiction of the United States, such suit or prosecution may, upon the petition of such defendant, filed in said state court at any time before the trial, or final hearing of the case, stating the